Hello, everyone, and welcome to Internet Law Review. For today's story, we are covering the case of Schein versus Archer. This is a United States Supreme Court case dealing with the Federal Arbitration Act. The Federal Arbitration Act is an act of Congress from the 1920s, which allows private parties to contractually agree that any disputes they have will be heard by a private mediator or arbiter rather than by a court system. The advantage of this is that it can be cheaper and much faster. The disadvantage of this is that it's off the record and that they tend to, at least in most people's opinions, favor institutional actors, that is, big corporations, and private parties, individuals, tend to be more disfavored. So we're going to read this and see what this has to say. Respondent Archer and White sued petitioner Henry Schein, alleging violations of federal and state antitrust law and seeking both money damages and injunctive relief. The relevant contract between the parties provided for arbitration of any dispute arising under or related to the agreement, except for, among other things, actions seeking injunctive relief. Invoking the Federal Arbitration Act, Schein asked the district court to refer the matter to arbitration, but Archer and White argued the dispute was not subject to arbitration because its complaint sought injunctive relief, at least in part. Schein contended that was because the rules governing the contract provide that arbiters have the power to resolve arbitration questions. An arbiter, not the court, should decide whether the arbitration agreement applied. Archer and White countered that Schein's argument for arbitration was wholly groundless, so the district court could resolve the threshold arbitrability question. The district court agreed with Archer and White and denied the motion to compel arbitration, and the Fifth Circuit affirmed. So here we have a threshold question. When a contract says that an issue is to be decided at arbitration, who gets to decide as to the legality or meaning of that particular provision? Because it's a provision in a contract that has to be interpreted, and so the natural question is, interpreted by who? So if you have a provision in a contract that says all matters in this dispute are to be heard by this private arbiter, the question is, does the arbiter get to decide whether or not that provision applies? Or is that a provision that a court would first have to decide in the first instance? Who gets the initial bite at that apple to decide whether or not that contract language applies? Let's read on to see what the court decided. Held. The wholly groundless exception to arbitrability is inconsistent with the Federal Arbitration Act and this court's precedent. Under the Act, arbitration is a matter of contract, and courts must enforce arbitration contracts according to the terms. The parties to the contract may agree to have an arbiter decide only the merits of a particular dispute, but also the gateway questions of arbitrability. Therefore, when the parties' contracts delegates the arbitrability of a question to an arbitrator, the court may not override the contract even if the court thinks that the arbitrability claim is wholly groundless. So we see the United States Supreme Court says right away that if the private parties say that an issue is to be held by an arbitrator, even if one of the parties argues, well, wait a second, this is a completely groundless argument. This is a completely pointless argument. This isn't supposed to be heard by an arbitrator because it's not a real argument. The court doesn't get to decide that because only the arbitrator gets to decide that. In the same way that if I had the right to sue you in federal court and you could say, well, this lawsuit that this person's bringing is pointless, it's without merit, I bring a motion to dismiss, would be a typical 12b6 motion in federal court. So you can absolutely do that in federal court if the lawsuit is without any merit. But the court here is saying, look, you've decided that this is an issue to be decided by an arbitrator. So whether or not this is pointless or whether it's frivolous or whether it's anything else, it's not for us to decide. You agreed that this other party is to be a judge. They're a judge for all matters. Go ask them whether it's pointless. It's not our call. Carrying on. Archer and White's counter-arguments are unpersuasive. First, its arguments that Section 3 and 4 of the Act should be interpreted to mean that a court must always resolve questions of arbitrability has already been addressed and rejected by this court. Second, its argument that Section 10 of the Act, which provides for a back-end judicial review of an arbitrator's decision if the arbitrator has exceeded his or her power, supports the conclusion that the court at the front end should also be able to say whether the underlying issue is not arbitratable, is inconsistent with the way Congress designed the Act, and it's not this court's proper role to redesign the Act. Third, its argument that it would be a waste of the parties' time and money to send wholly groundless arbitrability questions to an arbitrator ignores the fact that the Act contains no wholly groundless exception. This court may not engraft its own exceptions into the statutory text. nor is it likely that the exception would save time and money systematically, even if it might do so in some individualized cases. So what they're talking about there is if there was this ability to challenge things in sort of this front end manner, you can imagine that it would mean a lot more things to be decided by a lot more courts, because every person in every arbitration dispute would presumably go to court and say, well, this shouldn't really be heard by an arbitrator, and so it would take more of the federal court's time system. So even though in this particular case it might be true that the federal judge could save us all a whole bunch of time by saying this particular case is groundless, in the meta of all the cases, if that were true, every case would have to be heard initially by the federal judge, and that would take up a lot more time. And one of the things the Federal Arbitration Act was designed to do was to save the court time by taking things out of the court system and putting it into a private system. So even if it would be efficient in this particular situation, when we look at the global system, it would not be efficient. And that sort of makes sense. Fourth, its argument that its exception is necessary to deter frivolous motions to compel arbitration overstates the potential problem. Arbitrators are already capable of efficiently disposing of frivolous cases and determining frivolous motions, and such motions do not appear to have caused a substantial problem in those circuits that have not recognized the exception. Basically saying, look, the arbitrators, who are private judges, and for that matter, are often retired judges or are usually very experienced lawyers in their own right, they can handle this type of determination, which is fair enough. Their arbitrators are usually very, very experienced. The Fifth Circuit may address the question whether the contracted issue in fact delegated the arbitrability question to an arbitrator, as well as other properly preserved arguments on remand, vacated and remanded, Kavanaugh writing for a unanimous Supreme Court. So, long story short, the United States Supreme Court has once again strengthened the scope of the Federal Arbitration Act. Most contracts, especially from businesses to private consumers, have an arbitrability clause in them. You may not have read many contracts, but if you ever do, take a look at them. There's usually sections, usually in bold print to bring attention to it, that says that disputes can be heard in arbitration. Again, they have advantages and disadvantages. One of the disadvantages is it normally excludes class actions, and so it prevents people from pooling complaints together to get redress en masse, but it creates some efficiencies, and so is arguably of benefit or not to consumers. But as to the law, regardless of the policy implications, I think the United States Supreme Court is right. Whether or not you think the Federal Arbitration Act is a good idea or a bad idea, Congress, when they wrote it with some fairly broad and fairly sweeping language. And so these problems, which Congress has neglected to deal with since the 1920s, have just piled up on and on again. So, the Supreme Court here is unanimous. I can't disagree with their conclusion. The language of Congress is pretty strong, and it's up to Congress to change it if they want to. Congress may wish to consider whether arbitration provisions as it relates to business-to-consumer contracts are proper, or whether or not they should be further restricted. But that's a decision for Congress to make if they're ever going to make it someday. In the meantime, I guess be careful out there, because it's getting easier and easier for corporations to force disputes into these private courts, which do have some advantages, but do have a lot of disadvantages. And unfortunately, when the moment comes, you're not going to have the choice to sue that you thought you did. For now, my friends, that is all. I hope you're well. Cheers and goodbye.